HR Professionals is unparalleled. We're trusted to offer a comprehensive portfolio of advanced professional credentials for the HR professionals worldwide, and today, more than 500,000 HR professionals worldwide in 125 plus countries proudly maintain our credentials as a mark of higher professional distinction. HR Certification Center. Call or WhatsApp today on 0244 122 855. Why do 93% of the world's leading multinational companies prefer certified professionals? Because they tend to be committed to higher standards and ethics and maintain an informed intercultural competency. Whether you're seeking to build a career or to upgrade your HR professional career, you need to get trained and certified at the HR Certification Center today. Our experience in training and certifying HR professionals is unparalleled. We're trusted to offer a comprehensive portfolio of advanced professional credentials for the HR professionals worldwide, and today, more than 500,000 HR professionals worldwide in 125 plus countries proudly maintain our credentials as a mark of higher professional distinction. HR Certification Center. Call or WhatsApp today on 0244 122 855.
HR Certification Center commits to a higher standard. Certification Center commits to a higher standard. HR Certification Center commits to a higher standard. HR Certification Center commits to a higher standard.
It's a beautiful sunny day here in Accra, Ghana. Good afternoon to you, our online participants. Welcome to the HR Roundtable. In today's fast-evolving business environment, managers are not just responsible for driving performance, but also ensuring compliance with employment laws. Yet many find legal matters complex and daunting. This session aims to break down the key aspects of employment law in a practical and engaging way, equipping managers with the knowledge they need to make informed decisions, protect the organizations, and foster a fair and compliant workplace. Whether you are an HR professional, a line manager, or a business leader, this discussion will provide clarity on employment laws and its practical applications. Let's stay interactive. Send your questions and comments to the chat box, and I'll be glad to read them out. Remember, the HR Roundtable is brought to you by the kind courtesy of the HR Certification Center. Today, we are going to discuss employment law simplified, what every manager needs to know. And with me to do this are two distinguished speakers. The first of all, I will introduce Dr. Jeff Bassay. Dr. Jeff Bassay is a leadership and strategy expert. He is the founder of the HR Certification Center and also the Institute of Leadership and Strategy. Jeff has consulted and trained for over more than 200 organizations, including Bank of Ghana, MTN, Newmont Gold Ghana, Ghana Revenue Authority, Kempinski Hotel, Marriott Hotel, Coca-Cola, and Talo Oil. Jeff is a member of the University of Ghana Appointment Advisory Committee. He holds BSc Administration, LLB, MBA, and a doctorate in strategy. He is a chartered accountant and a certified professional in human resources and a certified strategy professional, CSP. Also, I have Yvonne Wiredu-Akpabli. She's a seasoned HR professional with over 20 years of experience across various industries, including NGO, telecom, media, finance, and shipping. She specializes in workforce development, employee engagement, and HR transformation. Currently, she's the Human Resource Director at a shipping company and was previously head of Human Capital at Data Bank. She's certified Senior Professional in Human Resources, USA, and a fellow of the Chartered Institute of Human Resources Management. Yvonne holds LLB and LLM degrees. Beyond her corporate work, she mentors HR professionals, speaks on HR trends, and supports businesses with their HR needs. She also runs the Tekwa Foundation, an NGO that helps young deprived girls. In 2023, she was named HR Personality of the Year at the HR Professional Summit. Yvonne enjoys farming, having fun, and is married with kids. Hello, Yvonne. Hello, Jeff.
Hello, and a very good afternoon to
Good afternoon, Doc.
our listeners. And thank you so much for having me.
It's been a while. Hope you're doing well.
Yes, by God's grace, we are well.
We bless God. All right, so Doc, let's go straight into it. How relevant is employment law to a manager?
Well, as relevant as you can imagine, Ghana is not a banana republic.
Right.
So long as you are an employer in Ghana, so long as you do business in Ghana, you come straightly under our labor regulation. And indeed, when you look at the Labor Act, the scope covers nearly every employer in Ghana. The only exceptions are the security agencies. I'm talking about the Ghana Armed Forces, the police service, the Ghana Immigration, Fire Service, prisons, etc. All the security agencies listed in Act 526 are the only exempted ones. Otherwise, every single employer, even if you are a foreign-owned organization, so long as you are operating on the land of Ghana, you come under a labor regulation, means that these laws must be very important to you, because flouting them, you then face the consequences thereof.
Right. Doc, let me tell you before I move on to Yvonne. Welcome, Yvonne. When it comes to employment laws, what are some of the employment laws that every manager must be familiar with to ensure compliance and avoid legal risk?
Thank you. And I am particularly happy you emphasize every manager, not just HRs, because
Right.
I have worked for quite a number of firms in this country in consulting capacity. And some of the time, they tend to think that issues of employment, and for that matter, the regulation that govern them, should be concern of only the human resources manager. No. Indeed, every manager manages people. And there's a concept in law simply known as principal-agent relationship. All managers' actions are interpreted in law as the direct actions of the employer. So whether you're a marketing manager, a finance manager, or operations, risk, etc., you are acting for and on behalf of the organization. And if by your actions the organization flouts any regulation, the organization will not be insulated from liability simply because you are not the HR. And so every manager must be concerned with employment regulation. Now, directly, you can talk about nearly all the labor regulation in Ghana that addresses employment, right from the Labor Act 651 2003, the Factories, Offices and Shops Act, the Workman's Compensation Law, the accompanying LIs. I'm talking about LI 1822, LI 1833. Simply put, all the labor-related laws govern very firmly employment. Indeed, we can even talk about the contract law of Ghana, because a relationship between an employer and employee is a contract. As much as the Labor Act tries to regulate, this relationship, we can also import generic contract law issues into the conversation, because once two or more persons agree for the fulfillment of certain duties, and once there is a failure, there will be liabilities. And so that even the constitution of Ghana, to a very large extent, have some impact on employment, especially so when all laws in Ghana are subject to the constitution. I mean, I'm sure in course of the conversation, we'll be citing some cases here and there, Clearly, in the case of those two National Fire Service ladies who got pregnant and were removed, the judge have to rely on the Constitution, etc., because the employer was making an attempt to control birth. And so the laws are sort of interwoven, interdependent, and it's difficult to say this one law is the only one that regulates employment in Ghana. There's quite a litany of them.
Right. Yvonne, just as Jeff has given us the key employment laws, and then every manager must be familiar with. So when it comes to the essential elements of an employment contract, how can managers ensure they are legally binding and fair?
Thanks, Hope. So when you take the Labor Act section 12, 13, and then there's a prototype of a contract in section 175. There are key aspects that the law requires that it must appear. First of all, the names and addresses of the parties. In most cases, because the contract is on the letterhead of the company, it is assumed that that is the employer, and then the staff's details are also there. Then the job title, the location of the job, when does it start, when will it end, the remuneration, the essential job functions, where sometimes the employer will attach a detailed job description. Okay, the essential, the compensation and benefits and other terms and conditions, things that you expect the staff to do and benefit from, things that you would also do for the staff to benefit from. And then how disputes will be resolved, and the big one, the termination clause. How would the contract be severed? It's very important that these aspects form part of the contract. These days, we call it the contemporary issues or gray areas, like non-compete clauses, confidential clauses, off-duty clauses are also supposed to be included. And since COVID also hit us, we've also introduced force majeure innovations in our contract letters, so that in case there's a disaster or a pandemic that requires that the contract, something happens to the terms and conditions of the contract, you cannot say that because we said this, we cannot change it. But the force majeure terms gives statements on how the contract will be handled in such situations. So these are the key elements that must come in a contract.
Right. Doc, I don't know if you have a follow-up to what Yvonne just said.
Well, she basically have covered the key areas as prescribed by the Labor Act of Ghana. Beyond what is in the Labor Act, a few things we talked about, call them important additions. The law might not have taken sacrosanct positions on these things, but if you don't take care of them in your contract, you are likely to have a few challenges, especially at the time of separation. The law hasn't cogently regulated probation, for instance. And I advise companies that it's a key area you should have position on when you are engaging in the contracting. And then for executive contract, we can have conversations on non-compete agreements, which strangely I've found so many companies now all of a sudden have woken up from their slumber and they want to smuggle, non-compete agreement into contract that have already been signed, So much so that sometimes they even threaten the managers, if you don't sign it, we'll terminate your appointment. If they are not part of the contract at inception, it becomes very difficult to smuggle in. So it's important that you take care of non-compete agreement. Non-compete agreements do come with a lot of caveats, if you may. For instance, you can't hold somebody's life to a ransom for good. And so the longest I've ever seen in the law is 2 years. You can't prevent a person from working for a competitor after he must have left you in same industry. These are all caveats, all right, for more than 2 years. And then it should not be administered to people who are not in decision-making positions, especially when they are not privy to strategies, business secret, and confidentiality, or classified information. Then it becomes very difficult for non-compete agreement to be binding. The final one is golden parachute. You can see a golden parachute as maybe an advanced form of redundancy, especially for people in key executive roles, so that in the event the organization gets taken control of, like another company buys it, something, when the original owners lose control through no fault of the employee, the golden parachute is more like a cushion for, if you may, some soft landing for these employees. They accept to take this package that insulate the organization from further liability. These are not things that the Labor Act have talked about should be put in the employment contract, but they are important additions. Otherwise, during separation, the organization is likely to run into some challenges.
Right. Let me stay with you, Doc. Yvonne can share her take on it later when you're done. But should line managers be concerned about employment laws, or is it solely the responsibility of HR or legal team? I'm not a lawyer. Why should I be bothered about employment laws? What would you say about that?
Is a question coming to me?
Yes, Doc.
All right. I've actually touched on that briefly already, that actions of managers are interpreted in law as direct actions of the employer, because all managers are acting for and on behalf of the employer. I hope we are here for only 1 hour. Otherwise, I have lots of cases to share on how line managers who are not abreast with the law tries to initiate disciplinary actions, they sidestep processes in disciplining the employees. Sometimes it's a bit too late by the time the issue is brought to the notice of the HR manager. And so because of their seeming lack of understanding of the law, they then commit the organizations into, if you may, avoidable liabilities. And so it pays a lot when line managers get themselves abreast with what the law say. Indeed, every manager is an HR manager.
Exactly.
Every manager is a people manager, because it is wrong for the HR manager to attempt managing the people in finance department, in marketing. It is their line manager who have a first responsibility of managing them. And managing people is heavily legally regulated in Ghana. The HR only becomes, if you may, a guide, an advisor, somebody who becomes a custodian, if you may, of the policies. Want to be sure that all managers. So you don't need to be an HR manager before you pay attention to what the labor regulation of Ghana say. Every manager must be concerned indeed.
Right. Yvonne, do you want to share your take on this?
Yeah, these people are the first line managers. They have direct relationship with the staff. They see them every time they are with them, and their actions impact these people much more than the HR person's actions or inactions. We've heard this saying that people don't leave their jobs, they leave their managers. So these people need to understand the implications of their actions. You'll be in the office and the manager will just walk to you. I don't think I can work with Amma anymore. I want you to sack Amma right now. And then in some companies, when the HR delay, they will draft the thing and give it to the staff. You come on Monday morning, you are looking for Amma. They say they've terminated Amma's contract. The worst one is where Amma will call you on Saturday crying that you didn't do well at all. You sacked. You have no information. Manager sat there and did it. Meanwhile, you, the HR, will go to the court or labor commission to go and defend the company. So these line managers need to understand. Sometimes issues like harassment, not sexual harassment, physical, verbal, emotional, they don't know how it can lead a company to court and bring liabilities. So they have the key responsibility, and that's why we as HR practitioners should run trainings for them. Beautifully enough, the center is about to run one. Let your managers attend. The previous one we attended, one manager just started laughing when Doc was talking about the procedure for terminating appointment due to non-performance. Apparently for them, once you don't perform, it be going that you are going like that. They didn't put the person through the process to determine whether the person is culpable or not and what the company can do. So they have to be trained. And you would agree with me, Hope, most of these people became managers due to their technical expertise. He came as an accounts officer, accounts supervisor, accounts manager, and is now the CFO. When it comes to accounting, finance, they are top. When it comes to people management, they are very poor. They don't know how to treat these people, let alone to understand that there are legal implications to what they do or not do to these people. So it's a direct responsibility of the managers, and like Doc rightfully said, with support and advisory from HR for them to do their bit.
Right. Let me pick up from where you mentioned about the legal trainers upcoming. My online participants, let me just give you this information that is coming, a legal training for HR and line managers. In that, you would have the models, foundations of law, HR policy and the law, workman's compensation, unions and collective bargaining, employment contracting, leave administration, employee discipline, employment termination. And this is just coming in about 2 weeks. It's going to start on the 8th of April. So you would want to register now. If you want to register now, you would have to call the number 020-800-7585, 020-800-7585 to register. Now, let me come back to Yvonne. How can organizations create workplace policies that align with employment laws whilst maintaining flexible for business needs?
So whatever policy you are creating is not in a vacuum. It must have basis in law. We have the Constitution. If you don't know what the Constitution is about, you know it's against discrimination of all forms. It allows for decent work. You have your Labor Act, you have the Workmen's Compensation, all of those laws are there. You need to first of all understand them, and then understand your business, your industry, and what you seek to do. You should also know your philosophy. Why do you exist? What do you want to do with your people? What's your people agenda? Then you enact your policies. Now, in as much as you want to be firm with the law, you are dealing with human beings. These are flesh and blood people with aspirations and the most dynamic species God created. And so you need to ensure some form of flexibility. That is why sometimes we say even though discretion is not good, there are portions that discretion must come in, where there's room for you to make certain changes to suit current issues. For example, you have a policy that maternity is 12 weeks, and then this person has gone on the maternity leave. Just when she's returning, she realizes she's pregnant again. So within the next 9 months, she would be coming for another maternity leave. If you understand the role of women, that is our productive and reproductive responsibilities, you will not take it too hard on this woman. You would rather put in certain things, even if it's not in your policy, to attend to the person, because you are dealing with human beings. And those are the areas that we need to train managers, because sometimes you go for disciplinary hearing and you realize they think it's a court or not court, but like some army barracks. A is A and it must be A no matter what. But you are dealing with people, different circumstances, even around the issue at hand. So as much as you want to have it rigid in law and to back it as foundation, make it also flexible to suit the people. This does not mean that when Amma wants the policy to have 18 days and Kofi wants 21 days, you make different provisions. You try to meet both of them at some point. So you see that most private companies, the leave days goes beyond the 15 days prescribed by law. So those are the flexibilities you bring in.
Hello, Yvonne. Right. I think Yvonne's network has gone a little
Okay, so I'm back. Yeah.
Sure.
Yes, thank you. So these things are not, once you have enacted them, as time goes on, you need to review them. Some companies do it every 3 years, some do it every 5 years. You can't say that when you started off, this is what you are doing and you keep it the same way. No. So you look at the law, you look at the people, you look at your business, you look at your industry, you look at the country you operate in. Okay. And then based on what you want to do yourself and the people you are with, you put certain things in place. Yeah.
Right. Thank you so much. If you're joining us just a while ago, this is the HR Roundtable, and we are discussing employment laws simplified. What every HR manager or what every manager needs to know. This is coming your way by the HR Certification Center. Kindly watch your screens for this short video. I'll be right back.
HR Certification Center commits to a higher standard. HR Certification Center commits to a higher standard.
Welcome back. Okay, this is the HR certifications, the HR roundtable, and we've been talking about employment law simplified. What every manager needs to know. We've already established the fact that every manager needs to know something about the labor, the employment law, so not to bring some risk to their business. Before we left off, Yvonne has given us some key points, same as Doc. Let me stay with Doc for this. Doc, what are the fundamental rights of employees and how should managers balance them with organizational policies?
Now, are you talking about right of employees in general or under employment contract?
Yes, Doc.
Yeah, I asked you two things. Which of them? Is it general rights or rights
employment law?
Rights?
Yeah,
Okay.
the employment law.
Okay, that's fine. So with the general rights, of course, they are put in Section 10 of the Labor Act, where there are rights of the employee, to be paid for the work it does, to work in free environment, for his health to be taken care of, etc. There are quite a number of rights as put in the section number 10 of the Labor Act. But quite aside from those rights, are also a few fundamental rights ranging from time to rest. Now, issues of rest, work hours are regulated from Section 40 going or upwards, and then the rights of entitlement to leave, etc. But if I want to speak specifically to right as stated or as required in matters of employment, An employee have a right to be employed. He also have a right to leave your workplace. And we always say that employment relationship is not a relationship of servitude, it's a relationship of service. And for that matter, resignation is actually determinable at will. The moment an employee says, I want to go, there's very little an employer can do to keep that employee. Indeed, virtually nothing except when the employee is undergoing disciplinary action. And so, and I've heard very funny stories of how an employee will tell you, I want to resign, but my employer say he will not accept my resignation. I'm like, which animal is called they will not accept your resignation? You are not taking permission from them. You are only informing them. All right. The only thing perhaps you are required to fulfill is notice requirement, which is in section 17, and if you mean 19 of the Labor Act. 17 talks about if the relationship is less than 3 years, you provide 2-week notice or pay in lieu of notice, and vice versa. The employer will also have to do the same if it's terminating you. It is only when the employment relationship is more than 3 years that you are required to do 1 month notice, otherwise pay in lieu. But there's something very interesting in section 19, why I encourage those who study the Labor Act to always read section 17 in tandem with section 19. Because section 19 talks about where there is express agreement between the employer and the worker, you will go by that. What it means is that section 19 makes nonsense of section 17. 17 is only activated when you fail to take advantage of section 19. So there are various rights the employee have: the right to leave, the right to rest, the right to limited work hours. And when you talk about the leave, we can talk about the annual leave, the sick leave, the maternity leave, public holidays. These are the only paid time off regulated by law: annual leave, sick leave, maternity leave, public holidays. All other type of leave may be good, but they are alien to the law. There's no law that says you should give your worker casual leave or bereavement leave or leave of absence with or without pay, and etc. They are all good practices if they are put in the law, but they are all good practices if the employer does them, but they are not required by what is stated in the law. So that is a few of the rights I can mention. Indeed, in disciplinary circumstances, the employee also have a right to be heard because of the presumption of innocence, that an accused person is innocent until proven guilty. In other words, you cannot try an employee, for want of a composite expression, let me use that word. You can't try an employee in absentia. But you see, as much as it is the right of the employee to be heard, as we all know, the two rules of natural justice, the audi autorem partem, and then the nemo judae in causa sua. Now, the audi autorem partem, which suggests that you must hear the other side. When a right is bestowed on a person by law, that right cannot be fettered by a third party. But guess what, Hope? The employee can sleep on his own rights. So when we say you have the right to be heard, and we provide opportunity for you to be heard, and you fail to take that opportunity, we can go ahead and determine the case in absentia. These are issues I've heard several times where an employee say, or an employer is worried about, we have written to the employee to come for disciplinary hearing. The employee is not replying, he's not coming to work. What do we do? I said, go ahead and determine the case. Just make sure you have evidence that you have provided opportunity for him to be heard, except he fails to take advantage of that. There are only two types of cases under Ghanaian laws that the victim or the accused must be heard at all costs: murder cases and divorce cases. All other cases, we only give you the opportunity to be heard. If you fail to take advantage, we go ahead and determine the case. So, but fundamentally, the employee have a right to be heard, have a right to even cross-examine your witnesses at disciplinary hearing, and all of those are all little rights that are imbibed in the law when we are maintaining a relationship with the worker.
Right. Thank you so much, Doc. So, Yvonne, what will be the best legal practices for managing employee misconduct, terminations, and grievances to avoid lawsuits?
So there's substantive and there's procedure. So you need to have a disciplinary code in place that tells the employee what constitutes an offense and how the offense will be dealt with. You also need a grievance procedure that gives the staff the opportunity to know that if something happens to me or if I'm aggrieved about something, there's a process for me to get redress. Because if you don't provide the information, you will not be fair in even implementing your discipline that you want to. You need to have these two in place: a grievance procedure and a disciplinary code, and each of them must spell the processes and procedures for going through it and getting fairness and justice. Let me put it that way. And then with the discipline, it must mimic the law with rules of natural justice, where the offender or the one who is suspected to have done the wrongdoing is given an opportunity to also speak. Okay, that's in law they call it the odi altering pattern. Let the person also be heard, and then you have it should be devoid of conflict of interest. Nimo Judes Incos as well. That's where the HRs make a mistake by being the judge, the lawyer at the disciplinary hearing. You are just there to coordinate and write your report and leave. Maybe at some point they will give you some feedback or pointers, but you are not the one to administer the whole justice process in the organization. And when you join the course, you will learn how to go about this disciplinary procedure. And then if you have a legal unit, they must be involved. The person's manager must also be involved. In certain cases, the person is allowed to bring in a witness or somebody to support them, who is the staff, to help their case where it's required. And so the process and all of this must be spelled out in policy. You don't wait for the offense to happen before you now put something together and you want to use it to administer justice. There's a saying in law that you can't give law a retrospective effect. If the law was not stated, the rule was not stated before it happened, you can't state one to use in administering it. So to deal with these discipline aspects, you must have your disciplinary procedure and code, your grievance procedure, and then train the managers. Most of the time, they make things difficult. A manager will query an employee, and that ends there. They've done it several times. Staff see queries as punishment. I'll give you query, I'll query you. A query is just,
It's an inquiry.
Yeah, you are asking the person to give you information. And then one of the things we also learned at the last session is that in the query, they've written that justify or state why you should not be punished or you should not be sanctioned, meaning the person is already guilty from the onset. Okay, you are just asking the person to explain the circumstances. What happened? Give me evidence. Okay, they caught you taking tea-roll from the washroom on Friday. Can you explain what happened? If it is true, if it is false, let me understand what happened. Then the next step is to determine from the explanation of the staff, is it something that should go through disciplinary hearing, or you can give him a verbal warning, written warning? That's also part of the guidelines for your disciplinary code, where sanctions are graduated: verbal, written, dismissal, in that order, depending on the gravity of the offense. And then even in this one, there are situations where certain people should not be on the panel. Certain people should not be there because either they will victimize the person indirectly, there will be some form of fear. And this brings us to the issue of the HR being on the ground when you know what goes on. except the company is so big, like the Newmonts and, the big ones that you will know people. But if you are 57 and you don't know them, you don't know much about them, it's difficult, especially to the managers. That personal relationship helps, so that you know that there was an issue between Yvonne and Hope. And so with this particular thing happening, Hope cannot be on the panel. He cannot be there, except where it's a bona fide responsibility of Hope to be there. Maybe Hope is the HR, so he has to be there to listen to it and make sure it's done well. So that's how the discipline should go on. But it all starts with education. Train the staff and managers to know the disciplinary procedure. What constitutes a minor offense? What constitutes a major offense? What sanctions will come with each of them? What processes will be used to sanction them? Another aspect that I also see going on in companies that we need to watch is the announcement of the matter. If it's dismissal, yes, you announce the matter and all of that. But you've given the person a verbal warning for an offense you think is minor, and it has been decided at the committee that it ends with the committee. Before you see, something is happening, and then the HR himself or herself or the person's manager, hey, you are doing this thing again. You be given another verbal warning, and that is constitutes a written warning. One leg out, and then people around are like, Yvonne, what did you do? What did you do? What did you? You can't die at that point. So the issues of confidentiality with these things are also paramount. And like Doc said, most of the things we do are intertwined. There are issues of mental health here for the person, whether it is true or false that he did that thing. If you don't handle it well, the emotional burden you are putting on that person, and if he goes home to say it to the family, on the family is there. And then you finish the whole thing and it is even false accusation. And you spread the whole news around the business that he was caught on camera stealing. So how the whole, yes, thank you. So how you even handle that? So in some companies, they handle these hearings outside the office space in a hotel or something. Some do it after work or early in the morning. And by 8, it's done. It's done. Yes. So people see you coming out from the room. If you don't say what you went to do, then nobody knows what you went to do.
Right.
And until the whole process is over and the final report has been sanctioned by whoever is responsible, then depending on the offense, you can announce. And these days, very little things, then people are sharing it on social media. You need to caution the staff. When they see the announcement, they are not supposed to take pictures of it and blast it on their social media. So when somebody does that to another disciplinary process, that has to start. So you need to let them understand, especially Gen Zs, everything they want to put on social media. So you need to also make them understand. So when you send out the information, have a red inked statement that this is for internal consumption, and that no circumstance should it go out. And that if it goes out, IT has the capacity to trace who sent it out, and the person will be sanctioned. You see that it will stay within the company. As much as you are implementing your discipline and sanctions and all of it, protect the staff. It's one of the valuable assets.
Right. Thank you so much. Let me go to Doug. Doug, what would you say would be the legal considerations should managers take, or what legal considerations should managers take into account when handling layoffs, redundancies, or dismissal processes?
Yeah, very well. Thank you. I guess Yvonne have already laid a foundation
Sure.
to that. You have to adhere to procedure. Now, we always say in law, procedure is as important as substance. You would have been dealing with an employee who actually had committed an offense, but because you sidestep process in dealing with the employee, you could your case could be compromised altogether. First, we want to be sure that the person bringing the complaint have the capacity to be the one to launch the complaint. There's something the lawyers call locus standi. It's a Latin expression. Who is the right person to or who have the capacity or the interest? You can't do a case on behalf of somebody. And I've seen organizations who have taken such cases from the employee who is not directly affected to want to listen to. Indeed, this before you terminate, you would want to probably start with a query. And like Yvonne explained, query is not a disciplinary punishment. And when she was addressing it, I was just smiling. If you see, Hope, the way some managers even shout, the way they even address, I'll query you, I'll query you. As if what is the meaning of query? It's just a document of inquiry. We want to find out what happened. The annoying part is how a company had put in. I have reviewed an HR policy for an organization. One of the statements I came across in that policy was how 3 queries was tantamount to or was equal to termination. How can you can query somebody 100 times when the person is exonerated by his response? So for you to even say 3 queries is tantamount to suspension of this means that it's a non-starter. You don't even understand. And in the case of Paul Kofi Abuaji versus Ghana Commercial Bank, the Supreme Court was absolute that query alone doesn't even suffice. Even if an employee admitted to an offense in a query, that does not suffice for disciplinary hearing. And you see, when you are doing disciplinary hearing, you are not only examining the circumstances that led to the offense. Like I said, procedure is as important as substance. Even to you, the employer, you are trying to gain intelligence on the conspiracy theory behind the offense. Is it all that account officer you want to sacrifice because of over invoicing? The account officer is not the issue. It is the chief finance officer who is instigating things. So even when you find him guilty and you fire him, a new person comes, you do the same thing. A proper investigation that leads to proper disciplinary hearing can even get the employer to come to realize the conspiracy theory behind it. Now, you must make certain that an employee did commit an offense before you terminate. Otherwise, then we can't for you. Now, when you look at Section 15 of the Labor Act, that talks about grounds for termination, Section 1515, then you jump to Section 62. I cannot demystify a lot of these things. The upcoming legal training for house and line managers will give us the opportunity to guide managers how to navigate and apply some of these principles or sections of the law. You see, the letter of the law is what everybody reads, the black and white, but the practice behind the law, the spirit of the law, the conventional wisdom, why those provisions are there, are the reasons we organize some of these workshops so we can crack the issues, properly. Now, so you look at Section 15, which gives the grounds for termination. You jump to Section 62 that tells you what type of or what grounds, if you terminate, your termination will be fair. But Section 63 talks about certain grounds that will constitute unfair termination. And for those of you who have been making this argument in Ghana that there's employment at will in Ghana, in which case you are saying that either party have the liberty to terminate employment relationship at any time, so long as you give notice. It's not true. We don't have employment at will in Ghana. Yes, there was employment at will in Ghana when we were under the Industrial Relations Act, Act 299, before the promulgation of the Labor Act. So in that law, for instance, Industrial Relations Act of Ghana, leave, for instance, was a privilege and not a right. But in the Labor Act, it is a right and not a privilege. So that old time. Now, specifically Section 63, subsection 4, talks about how in the absence of grounds or reasons for termination, the termination will be void. I'm sure our listeners will want to read some of these things, sessions for themselves. And so supported by the case of Kobe and the 24 others versus Ghana Manganese Company. I can't discuss the details of the case because of time constraints, but the presiding judge was quite clear on the issues that once an employer fails to prove that termination was done in accordance to law or have cogent grounds, it will be considered unfair. So the right to terminate does not lie at the whims of an employer. You must be sure that there are certain red flags. I'm not sure I will be teaching termination in the labor, but at least I'll be doing contracting, and I'll also be looking at the law and some policies here and there. I would have the opportunity alongside my colleagues. There'll be some lawyers who would also join us in delivering this training. We will have time to then, crack the issues and help our audience to navigate all of it. You see, when I hear people say, at the end of the day, this is how we do it here, there is what I call the price and the cost of everything. That termination may be the price because you are willing to just pay off when the employee sues, but the cost to the organization, avoidable cost to the organization. I was telling some students of mine the last time that if you don't understand damages, remember Kennedy Ejapong and Kennedy Ejapong and Anas. You will understand the impact of damages on your organization if you just fail to train your people or train yourself or do the right thing. Some HRs have been reduced to tools in the hands of CEOs. They used to perpetrate anything they like. And more of it is because the HR himself is not well grounded in the law. And therefore, you are not positioned to advise your CEO. Yes, HR, you don't have to be aggressive. I normally liken the role of HR to that of Jesus Christ. You are a liaison between God and man. God in this case is management, man in this case is the staff. Whilst you are asking God to forgive, you are also asking man to repent. So you don't have to be aggressive. But when a CEO gives a directive that you know is against the law because you know the law, you advise using the law. Leave the CEO alone. Many of them will by themselves rescind their own decisions. But if you do not know the law first and foremost, then if he's directing you to flout the law, you will ignorantly do it because you first and foremost do not even know the position of the law. And at that the labor law, the legal training we are about to do, I'll share a case that have to do with how an HR himself got fired because a CEO directed him to fire somebody. The HR fired, only for the guy to go to court, and then the court will now have to go through the processes the organization sidestep. That was the first time the CEO got to know, oh, so we're supposed to do A, B, C, D before we terminate. You HR that you didn't advise me on means you are not competent. He was fired. And the HR also went to court. Oh, he lost the case because one of the duties of an employee, in this case, including HR as an employee also, is to be conscientious in your lawfully chosen occupation. You must know your work. Otherwise, then we can terminate your appointment for not mastering your labor laws, for which reason you become the chief people advisor to management.
Right. Thank you so much, Doc. Doc, let me stay with you briefly. Someone would want to find out. So, what would be the proactive steps that managers can take to minimize legal risk? What would you say briefly?
Right. So one of the trainings I do, or let me say I have done in time past, I hardly do that now. My focus really is on strategy now. Hope knows that.
Yeah.
Those days when I was vehemently training HR and labor issues and all of that. I mean, companies like Ghana Ports and Harbors Authority will get you to run training for all managers. They call it HR for non-HR managers. And half of what we are discussing are labor regulation. I've done same training for Casapreco in time past, where all managers are in the training and all we are discussing is HR legal issues that affect you and your employees in the organization. Hope in the legal training we are about to do, we will cogently decipher the roles of an HR in legal issues in the company and the role of the line manager. And we'll take it, area by area. Employment, for instance, what is the role of the HR? What is the role of this thing? Contracting, what is the role of HR? What is the role of the line manager? Even onboarding, there are instances where employees' probationary period is surpassed. The company have gone beyond the probationary period. It is after. So let's say you get employed in, say, January. Your probation ends 30th June, and then sometime July 15, the line manager then calls the HR. This is a true story. I'm telling you. The line manager then calls HR and say, I'm not feeling this guy. I don't like him. I don't think we can confirm him. And then an HR got to me complaining that why is it that the line manager did not complain about this guy way before the expiration? My friend, you as an HR should also know that when you put an employee in a technical function or in an operating department, there's a relationship between the HR and the line manager. First 1 week, what are we reviewing about the person's performance? What is the role of the line manager in working on that person? What is the role of the HR? First 1 month, second month, in that order. And what I'm saying to you now can be applied to nearly every area, from employment to onboarding to employee discipline to career counseling to performance management. What are the functions of the line manager? What are the functions of the HR manager? And when one of the two reneges on their responsibilities, you can drive the organization into those avoidable liabilities we are discussing here.
Thank you so much. Thank you so much. If you're just joining us, this is the HR Roundtable, and we are talking about employment law simplified, what every manager needs to know. And there was this coming program that you must be part of. There's a training, legal training for HR and line managers. You say, I'm not an HR person, so must I know the law? You definitely must know the law. And we are going to have we have about 8 models in the training. Foundations of law, HR policy and the law, workman's compensation, unions and collective bargaining, employment contracting, leave administration, employee discipline, employment termination. All of these is going to start on the 8th of April. That's just like next week. And you can call 020-800-7585, 020-800-7585 for registration. Can you do that now? Please watch your screens for this break. I'll be back shortly. Right, welcome back. So I have lots of comments and questions in the chat box. But before I go into the comment section, Yvonne, are verbal agreements legally binding in employment contracts?
Yes, but it depends on the duration. Section 12, yes, of the Labor Act says that every contract of employment that would, for a period of 6 months or more, or for a number of working days equivalent to 6 months or more within a year, shall be secured by a written contract. So if the contract will not be 6 months, you could. But there's also a contradiction of this same law where it says that when you join a company within the first 2 months, you should be given all the written documents covering the agreement. And when it comes to employment, we encourage candidates to wait and get a written document that shows you the terms and conditions before you start. Sometimes in our zeal to work for the company, especially where we think it's a well-established company, they will not lie. After the interview, they call you and say, oh, Hope, thanks for attending the interview. You've been selected for the role. And since you mentioned you can start on Monday, we'll be expecting you. Then you also go without any terms and conditions governing that relationship. Then you are there 7 days later, they tell you your contract is terminated and you have nothing to base it on. So even though there's some small space be somewhere, I don't think it's something that we should play with. Yes, we shouldn't play with it. We shouldn't play with it.
Right.
Get
Thank you so much.
secure yourself a contract letter. And this brings me back to the line manager issue. They will give you HR pressure. We need the person. My department, I cannot achieve my target. And so bring the person. Let him start. You can do the paperwork later. And HR, in his zeal to show this manager that I'm a listener, calls this candidate to come and start without the documents. It is dangerous. It's dangerous. Yeah.
Right.
Well, just to add a quick to that, to add a quick one to that, Yvonne indeed had done justice to the question. Yes, you can. There can be an employment relationship or contract enforceable at law, even without document, because the section 12 she mentioned, which is what talks about contract first in the Labor Act. Then there is 175 that talks about a contract can be express or implied. Or let me say written or oral, and even if it is oral, it can even be implied or express. All right, so there can be, but you see, like Yvonne mentioned, in the absence of a written contract which cogently mentions the code of conduct or how the employee must carry himself, between the employer and the worker, the employer is more disadvantaged. What it means is that the employee can get away with so many things. Because, in law, until you define an act as an offense, you can't declare it an offense only because it is done. I'll say that again. Until you define an act as an offense, you can't just get up and say that this is an offense. We don't consider what is an offense with your moral compass. You don't just say, well, this is not right, doesn't sit well. How do you did you define it? If stealing in Ghana was not in our criminal code, all goat thieves will be angels. And so you don't just get up and say, this thing you did is unethical, therefore I'm terminating you. Ethics is not even synonymous with legality. Justice is delivered on law and law only. Justice is not delivered on morality. It's not delivered on what Bible says. It is not delivered on common sense. It is not delivered on emotions. So that your policy is actually a law that governs your workplace. If you do not give a written contract and tell the employee you cannot do A, B, C, D, and the employee does it, there will be no basis for which you can punish the employee. Yvonne had already spoken to the gray areas. Those gray areas in the law doesn't mean the law is incomplete. In the mind of the framers of the law, those areas were left on purpose for employers to enact policies to regulate them. There is nothing against gift in our Labor Act. The law is against bribery and corruption. There's nothing against gift. There is nothing against office romance in our Labor Act. The law is against sexual harassment. There's nothing against off-duty conduct. There is nothing against outside employment. These are things the employer must put in the contract that you deliver. So if you don't put them in the contract and the employee goes against them, then you come and raise your moral compass and say that this is not done, and so you are wrong. Well, terminate the employee unless the employee doesn't know his rights in law. And when I used to do labor practice, I've done several cases at the National Labor Commission. When I see these cases, I start laughing ahead of our going there. Like in one case where a female teacher of a mission school, these churches who establish schools, Pentecost, Presby, Methodist, they have so many schools around. And the school have a policy that says that they don't subscribe to divorce. And the woman went through divorce, and which was granted by a competent court of law. I always say not a kangaroo court. And then the school says that because we don't grant, Bible is against divorce. Justice is not delivered on what the Bible says. Justice is delivered on what the law says. And so in preparing your policy, one, make sure you put in everything you don't want. But whilst you are putting in those things too, you must make sure they are analogous with state regulation, because putting in policy statement that runs counter at the law, you would have been contracting your organization out of legislation. And to the extent of the contradiction, your policy statement will be void ab initio. The statement void ab initio means that the day you put it there is the day it didn't carry any effect. You can be happy about yourself that you are put it there, but it doesn't carry any weight in law. In the event it was tested at courts, or at law. Right. Sorry.
Doc, thank you so much. Doc, let me stay with you. We are far behind time. We've gone past our time. Let me spend some 5 minutes. But let me ask this question: can an employee's disciplinary record be expunged after a certain period, and what criteria apply?
Well, I am yet to come across any such thing that employee disciplinary period will be expunged if the employee is still with the company. No, I haven't come across it. Maybe Yvonne may have some knowledge to share with us. What I know is that when an employee leaves your organization, you may keep the employee's records for up to 5 years. After that, you can dispose of the record. But so long as you are still with us, I don't have knowledge on that. Whether we say that after a period we expunge your disciplinary records from the books. I don't think there's anything like that in our books, unless maybe my colleague thinks otherwise.
Yeah, Doc, it's not really an expunging thing where you take it off. It's on file, but in most cases, there are policies where after 2 years, that offense
Yvonne was really providing us with some good knowledge there, but it looks like
internet is good. Yes, she's back now.
Okay. Some companies will say that if you get 2 written warnings in a year, your appointment will be terminated. Okay. And so if so it's not like Doc mentioned, but the issue is, why do you want to take it off the records? Because once the staff is with you, you need this history to help you to know even how the person has grown. Yes, he committed a great offense. He was punished for it. He has outgrown it. He's changed the way he does things. He's now working better, giving results. That alone is a good, I would say, like a practice which you can use to encourage people. So you don't delete it from the files. Just that to use it to sanction the person again, that's where you have to be very careful. Once you've dealt with it and it's passed, it's passed. Unless your policy has some dimensions. But with this one, to let us understand that you can't punish one person for the same offense twice. It will fall under the double jeopardy thing. So in sanctioning them using past offenses, we have to be very careful. And so we say treat the matter in context. In the same way we sent you to Takrady and the tea rolls got missing. These batteries too are missing. It shows you can still, it's 2 different issues. He may not even know anything about the batteries, but you are bringing the tea rolls that got missing to show that he has the propensity to steal. And the office is not the Lombroso, whatever, that you can use somebody's face or head dimensions to determine their propensity to crime. So expunging, no, but you should keep it on record. You should keep it on record. When the person leaves you, then there's also the other aspect, Doc, where the new employer is asking you for records for reference. And then this offense was committed in the year of the issue. You say it or cover up. And so that's why you need to have the years thing so that you know that, okay, if it happened 2 years ago, I don't have to mention it to the new employer. But if it happened in the year and it is something that I feel will put them at risk of a form, I should mention it to them if they decide to still employ the person.
Right. Thank you so much, Yvonne. Let me go to the chat box. Having a couple of lots of questions there. But I'll just pick a few because our time is fast spent. Robert is asking, just as an employee has a right to terminate without stating the reasons for that, does the employer also enjoy the right to terminate an employee without stating the reasons? Yvonne.
Pardon? Sorry.
So just Robert is asking, just as an employee has the right to terminate without stating the reasons for that, does the employer also enjoy the right to terminate an employee without stating the reasons?
So this particular issue, there are two legal schools of thought. A group of the judicial, the legal people say that just as you can give your resignation without reason and say it's personal and go, the employer can also terminate your appointment without reason. And then there's also another school of thoughts in the legal sector who say that no, you are the one you are in authority, you have power. If you are letting the person go when the time for the term for the contract has not reached, you should give the person a reason. So it depends on the judge you meet at the commission the day you go, going under the reason. Yes, but I think here Doc will talk more. He has the cases to back these things. Yeah.
Doc, any take on that?
Well, Yvonne has spoken to it, but largely, the Labor Act is designed to be more protective of the worker relative to the employer. The idea is that between the two parties, the employer is more powerful, like Yvonne have mentioned. So I would say no. Unfortunately, no. The employer will not have the same liberty to terminate without reason, much as the employee can go without. You see, you don't owe the employee the reason. You don't owe an employee a reason when you are terminating. You owe the court. So you can write a termination letter to an employee without stating all the cogent reasons why he has to go. When the employee doesn't take you on or allow sleeping dogs to lie, we move on. But if the employee, challenges the termination at either the traditional courts or a quasi-judicial body as the National Labour Commission, then you are required to state or to provide reason to the court why you terminated. I hope you understand. So not providing a reason or grounds to the employee is not the same as not having grounds. Okay. Mm-hmm. When you are challenged, the court then will demand the grounds from you, and your failure to provide them then becomes a bit. So Yvonne, I belong to the school of thoughts, and I can back it with loads of cases where an employer doesn't have the liberty to terminate without having grounds. You may not owe the employee grounds, but you need to have the grounds so that when the employee challenges you, you can see to yourself. Because many employers who eventually get challenged by the employee at the law court and have not been in a position to provide reasons, have most of the time not prevailed in their cases.
So, Doug, let me stay with you. Loretta's asking, please, how do we treat a project staff who is on two projects with 60% time allocation on project A and 40% on project B? Now, project A is terminated due to the stop work order. How do we treat his severance pay?
Okay, so Hope, generally, by law, every Ghanaian worker must have one employer. No Ghanaian worker have two employers. So I want to believe that the two projects are managed by the same employer, because you cannot be an employee of two employers in Ghana. As far back in 1996, South Africa have changed their laws where an employee can be a worker or a worker can be an employee of two employers. But in Ghana, it is one. So I want to assume that the two projects are managed by the same employer. If that is the case, now we always say that you can't give a job that is available and continuous on fixed-term contract basis. Now, if you want to know what type of contract to deliver at what circumstance, you may want to read section 73, 74, add section 75, jump to section 78, and there's a lot of education there in the law. All right. So now you can't give a job that is available and continuous on fixed-term contract basis, except the jobs are seasonal, sporadic, the employee is coming on the back of a third-party employment arrangement, or it's a project-based job. We all know project-based jobs are jobs that have definite start time and finish time. To the extent that that can be given on a fixed-term contract basis, the law will always prefer that the contract that regulates the two parties, the employee, the employer, is what we will revert to when it comes to severance, for instance, or severance pay. Now, severance is really not a mandated thing to be paid in Ghana. We can't, you see, some people will challenge this as it sounds very controversial. I'm sure when you come to that training, we will convince you why so. All right. So it is more regulated by policy contractual agreement than what the law says. So if it is a project, we have to go back to the same contract between the two over the project, because under normal circumstances, the contract only lasts by the life of the projects. So when a project comes to an end, when one part of the project comes to an end, we'll go back to the same contract that talks about, did you give me a 2-year contract and one had ended? If it will end before, what provisions have we made in the contract between us? So it is difficult for me to use state law to answer this question. We must read the contract between the two about this. And a lot of these things happen also an extension of the SLA, the service level agreement between the mother company delivering the project and the beneficiary company who have awarded the contract. We have to read the SLA and the contract of engagement in tandem to be able to respond to the issue, because your agreement becomes contractual and becomes basis for legal enforcement at law. Yeah.
Thank you so much. I think our time is fast spent. Let me pick your closing remarks. Yvonne, what would you say to someone who is watching us when it comes to employment law? What will be your closing remarks?
Yeah, we are at a point where you can't claim ignorance. Already, ignorance of the law is no excuse. Whether you are a line manager, whether you are in HR, you should understand the laws that govern employment, your job, and the people you lead and manage. So it's this upcoming training is an opportunity. If the timing is not suitable for you, reach out to Dr. Bassay or Hope. We'll come and do it in your company for your managers. Managers are the first line people dealing with our employees. When they don't understand or even know the legal implications, the risks they bring through their actions or inactions, the company is also put at a huge risk. And this can be avoided by having information through training and sessions like this. So thank you very much for the opportunity and also the content of this delivery. I've equally learned a lot. Yeah, thank you.
Thank you so much, Yvonne. Doug?
I've also learned from you can't come and learn from me a good stuff. Folks, I think that if you want to be taken seriously as a manager, particularly as an HR manager, you must have mastery over labor regulation. Mastery over labor regulation builds your confidence and solves half of your problems as an HR manager who wants to do the right thing. That's all I want to say. Seek to have absolute knowledge on the law. It builds your confidence, and you are halfway through solving almost all your problems, halfway, when you have knowledge on what the labor regulation says.
Impressive. Thank you so much, Doug. I remember in one of our sessions, Doug mentioned that as a HR manager, you must have the labor law at hand. Know it, Baba. From at Kowa says she wants to wear, but know it, chew it, Baba. It should be your Bible. You cannot be an HR manager and don't know the law. You definitely must know the law. And if you are an HR manager or a line manager, you must be part of this training. This has been the HR Roundtable, and we've been discussing employment law simplified, what every manager needs to know. And they're just coming training, legal training for HR and line managers, and they are in 8 modules. Like I said, foundations of law, HR policy and the law, workman's compensation, unions and collective bargaining, employment contracting, leave administration, employee discipline, employment termination. And this is going to start on the 8th of April to the 2nd of May 2025. We'll start from 6 p.m. to 9 p.m. It's a 4-day week, Tuesday to Friday. So you have in 4 weeks you should be done. And this is going to take place at the HR Certificate Center Training Center at East Legon. You can call 020-800-7585, 020-800-7585 to ask any questions that you want to, or you want to ask, or you want to make some inquiries. You can call the number, or if you want to register, you can call the same number. I say it again, 020-800-7585. This has been the HR Roundtable, and I'm thanking you for joining us for this session. Thank you, Doug. Thank you, Yvonne, for being part of this session. We look forward to seeing you same time, another time. God bless us all.
God bless you too. Bye.
Bye.